All right, well, good afternoon, everyone. This is Will Burns with ACCE. We're going to go ahead and kick off our webinar this afternoon. Thank you for joining us. We're here to talk about NAFTA, and I wanted to give everyone some quick housekeeping items before we launch into everything. So what we're going to try to cover today is, obviously, it's been a busy week or two, so we want to update everyone on the latest news. We want to talk about where things stand and where things go next. And then we want to make this as interactive as possible. So we want to ensure we leave plenty of time for question and answer. And I would encourage you to use the GoToWebinar tools throughout the process if you have a question. So there's the hand raising feature where if you're logged in with an audio pin, I can unmute you and you can ask your question. There's also the question box. So feel free to type in questions into the question box, and at a break in the discussion, I will chime in and ask the questions for you. So just brief introductions of our speakers today. First off, we have John Murphy joining us. John is Senior Vice President for International Policy at the U.S. Chamber. So he directs all of the U.S. Chamber's advocacy related to international trade and investment policy. We also have Mark Agnew joining us. He's the Director of International Policy at the Canadian Chamber and Executive Director of the Canadian Services Coalition. And he's responsible for managing the Chamber's international work, including trade policy. So with those brief introductions, I will kick us off and dive into the content and hand off to John. John?
Thank you very much for that introduction. It's great to be here with you all today. I think what we'd like to do first is just share a few thoughts about the economic importance of the U.S. relationship with Canada and Mexico and why NAFTA matters, and then rehearse a bit of the history of how we got to today over the past going on 2 years of the effort to renegotiate NAFTA. To kick it off, NAFTA matters because about 14 million American jobs today depend on trade with Canada and Mexico. Those two countries are by far our largest export markets. For manufactured goods, for instance, they buy more made in America manufactured goods than the next 10 countries on the list combined. And there are benefits for every state. Nearly 40 states have either Canada or Mexico as their top export market, and trade has risen dramatically since NAFTA was negotiated about 25 years ago. They're also our largest growth markets. U.S. exports to these two countries have expanded more over the past decade than our exports to any other country in the world by a very large margin. And it's not just manufacturers, which I mentioned, that are extremely dependent on the Canadian and Mexican markets. American farmers and ranchers are perhaps even more dependent on these two markets. U.S. agricultural exports to Canada and Mexico have quadrupled since the agreement entered into force. They are our top markets for commodity after commodity. There's only a few exceptions where that's not true, that a particular commodity is shipped elsewhere to a greater degree than Canada or Mexico. And it holds for services companies as well. U.S. services firms, which often have to invest in Canada or Mexico to do business, whether it's in banking, insurance, or express delivery, they also do good business in both markets. And it's not just for big businesses. American small businesses benefit from trade with Canada and Mexico as well. There are about 125,000 small American exporters that sell their goods and services in Canada and Mexico. That's much more than any other markets in the world. So that's a little snapshot of how it matters to the U.S. economy. Turning to the history of this renegotiation, we find ourselves at what seems to be a pretty important month in this effort to modernize a 25-year-old trade agreement. Now, I think we've all heard the president call NAFTA the worst trade deal ever. He said this on many occasions as a candidate and as president. What we've seen in practice, though, has been a process that began in May of 2017 with the administration sending a letter to Congress notifying its intent to renegotiate the agreement, to modernize it and address what the administration believes to be long-standing problems with it, but also just to address areas where modernization is called for. Just to give a couple of examples, it doesn't really have any e-commerce provisions because e-commerce didn't exist in 1992 when it was being negotiated. It doesn't protect the intellectual property for medicines we call biologics because they didn't exist back in 1992, and so on. So negotiations began in August of last year. They initially were held in what are called rounds in different cities. The business community has been very much engaged, including the U.S. Chamber of Commerce. However, we have had concerns about a number of the proposals that have been put on the table. Some of these we've called poison pills because we think that they would actually raise barriers to trade rather than reduce them. The negotiations move forward in fits and starts, but what's changed now is that the U.S. administration has found a bit of leverage, and that leverage comes from the fact that Mexico has elected a new president. Andrés Manuel López Obrador takes office on December 1st, and the outgoing government, for various reasons, and backed by the Mexican private sector, has been very interested in seeing these negotiations wrapped up. And to do that, they want to see the agreement signed by the three governments before the current president leaves office. He leaves office on December 1st. Now, for the outgoing administration in Mexico to sign this agreement under the U.S. law, negotiations must be concluded and the agreement made publicly available by the end of September. So this is a real point of leverage. We've seen last Friday the administration, which has wrapped up many of the bilateral aspects of the negotiation with Mexico. On Friday, the administration formally notified Congress that it intends to sign this agreement on the last day of November with the Mexicans, and hopefully have the Canadians present as well for that. Now, in the past week, it's been very clear here in the United States, and I'll turn to my colleague from the Canadian Chamber of Commerce here, but here in the United States, there's an insistence from Congress and from the U.S. business and agriculture community that we need a trilateral agreement. We need Canada to be part of it. I think it's highly questionable to argue that an agreement that excludes Canada, which is our largest export market, that it would win approval by Congress. And I think that on some level, this is widely understood here. So it's a big month. The effort is underway here to wrap up negotiations in a way that is for real, in the sense that the text will be made public by the end of the month. So with that, I'd like to turn it over to my colleague, Mark Agnew, my counterpart from the Canadian Chamber of Commerce.
That's great. Thanks, John. And I should say also to the group, thank you very much for the opportunity to speak here with you today. It's always great to speak with our colleagues across the border to let them know what we're thinking. And of course, I look forward to hearing through the Q&A some of the views from yourselves about how you see the process unfolding on your side. So maybe just to sort of step back in the same way that John did with some of the history from the Canadian perspective about the agreement. The agreement has clearly been very beneficial for Canada's economy since 1994, when it first came into effect. Trade with North America has gone up, will double in terms of the United States, exports to the United States, and actually tripled in terms of Canadian exports to Mexico. The Canadian economy is very heavily dependent on trade. We're definitely nowhere near the size of the U.S. economy. So the sort of saying that you hear a lot of people use up here is that whenever the United States sneezes, Canada catches a cold. And I think that saying embodies some of the disproportionality in the relationship. I believe the figure is something like, U.S. GDP is only about sort of 1% or 1 and a bit percent dependent on trade with Canada. Looking at that number in reverse, slightly over 20% of Canada's GDP is dependent on exports to the United States. And I think that disparity just gives you a bit of an indication as to how much this agreement does matter to Canadian businesses. And if you look at the rankings of Canada's export markets, I think you'll see that play itself out in the numbers as well. When you look at goods trade, the United States is the destination for 75% of Canada's exports, whereas Mexico is only 1.5% of Canada's goods exports, and the numbers are slightly different on services, but largely in the same neighborhood. So I think when people really talk about the importance of NAFTA to the Canadian economy, it's in some respects actually more aptly described as the importance of the United States to the Canadian economy as an export market. And another sort of commonly cited figure here is that a car in their production life cycle will cross over the border 7 times because of the nature of the integration that exists between the two countries' economies. Now, since 1994, I talked a bit about the numbers and how trade has gone up substantially over that period. I think it's fair to say that the way Canada has seen, the NAFTA process has been to try to, over that 25 years, look for opportunities more to tinker on the margins with it, and more about making sure that, the border was as seamless as possible, which became quite difficult, certainly after 9/11 for understandable reasons. And there was a push during the years in the Obama administration to focus on regulatory issues through something known as the Regulatory Cooperation Council, which unfortunately for a variety of reasons never really did live up to its full potential. And so against that backdrop, when the NAFTA renegotiation, more correctly, presented itself, the Canadian government actually readily jumped at the opportunity and really saw it as a chance to modernize the agreement substantially for the first time in 25 years. And John alluded to some of this already, particularly around things like the e-commerce chapter, which, to reflect the, advances of the digital age. Other areas where the Canadian government came into this fairly optimistic and hoping to see the agreement expanded. We're also in areas like labor mobility and expanding the list of professions that are covered by the TN1 visa provisions in the agreement. Thinking about how access to each other's procurement markets could be expanded, and from the Canadian view, particularly state-level procurement in the United States there. So I think the thinking over the course of the last year or so since the negotiation started has certainly evolved when you speak to folks here. I mean, unfortunately, the tone and the tenor of what's been coming out of the White House has, in some respects, led the Canadian business community to focus perhaps a bit more on, defending the agreement. There are certain aspects sure that, that are being modernized, but perhaps the ambition that we came into this at the outset is not as great as it once was for a variety of reasons. And I think some of the things we've seen, for example, on the steel and aluminum tariffs and the auto tariffs, have just made it quite difficult to really advance the agreement and to use this opportunity to modernize it in the way that was originally envisioned. I think the other thing to say about kind of just where we are in the process before we talk about some of the issues is that this issue about NAFTA and the renegotiation, I think as a byproduct of the disproportional nature of the trade relationship, this issue is huge in Canada, and I don't think you can really fully understate that point in any way. I mean, it's on the front page of the major papers every single day. Whereas, the sense we get in the United States is perhaps it's not as high profile outside the Washington Beltway, but here it really is an issue of true national importance, and the outcome does matter massively to the Canadian economy. So maybe I'll stop there and give it back to John, and we can start to talk about some of the substance in the agreement.
And John, do you have us on mute?
I do. Thank you. Thank you for that. And we're looking forward to turning to the Q&A in a minute. But first, want to share some perspective on what's actually in the agreement as we understand it. Now, since August 27th, when the United States and Mexico reached a so-called agreement in principle, the Office of the United States Trade Representative has issued a number of fact sheets, and other information has come to light about the nature of that deal. Now, this is not the complete agreement, obviously, because Canada isn't on board, and there are some trilateral aspects that cannot possibly be concluded, obviously, without Canada there. But a good share of what the United States was hoping to accomplish in these negotiations focused on Mexico. So there are substantial commitments here that the Canadian government has been engaged in and in some cases signed off on. Others, this state is not quite well known. So let me walk through a few of them. First of all, let me name a few areas that we have some serious questions about that might be problematic. And I think at the top of the list is the auto sector. Now, the automotive trade in cars and auto parts has been a major focus here. And what the administration is proposing to do is to raise substantially the so-called rules of origin, that 3/4 of the content of a car would have to be made in North America to qualify for duty-free treatment. Now, this is a big increase over the NAFTA 1.0 commitment of 62.5%. But what's being proposed here is that, in addition, a high percentage of the steel, of the aluminum, of the transmission, and a couple of other elements all have to meet these high requirements. And this could be problematic for the auto sector for a couple of reasons. One is that it will cost tens of millions of dollars to have the kind of bureaucratic tracing that's involved in all of this to be able to prove that your car qualifies. And second, it's a global reality today that there's always elements that are being made around the world and brought together through global supply chains. And these requirements, by threatening to really increase that requirement, it's going to raise costs. And it's estimated that the consumer at the end of the day will pay significantly for this. Other areas that are on the table right now, we have question marks about the procurement chapter. A lot of American companies in both Canada and Mexico are able to bid on government procurement opportunities in sectors from insurance to water and wastewater contracting opportunities with municipalities, and it's good business. The U.S. has proposed to basically turn off, to a large degree, that market access. We at the U.S. Chamber have argued that that would be a bad deal because in Mexico, for instance, U.S. companies do billions of dollars of business in this area, but Mexican companies do almost nothing in the United States. So this is a proposal that would bring harm to U.S. industry without any particular benefit. Sectors as well, like oil and gas, are concerned about weakening the investment protections in the agreement. Oil and gas companies, after all, have to go find deposits of these resources to extract wherever geology put them. And it's not a question of offshoring jobs, but it has been proposed that the investment protections in NAFTA would be weakened. Other areas where it's just too soon to say, we just don't have enough information, include the proposed sunset clause. The U.S. administration initially proposed that NAFTA 2.0 would have a 5-year sunset clause such that it would more or less automatically terminate unless all three parties agreed to keep it. Now, what I hear from our members here at the U.S. Chamber is that's a problem because companies make investments on a very long-term horizon. They do so on the basis of an assurance that they're going to be able to access the customers that they depend on. And if you have such a short time frame for a trade agreement, then those investments won't be made and the jobs won't be created. Now, in recent week, we've heard that this has been altered to a 6-year review period and a longer 10-year phase out of the agreement. We still have question marks about this, though. Very little information has come to light on this. We also have questions about energy provisions. In a very late stage in the negotiations, the Mexican negotiating team wanted some changes relating to energy. A lot of U.S. energy companies are interested in investing in developing Mexican energy resources, and we don't know how that came out. Now, there are other areas in the negotiations that we believe are positive. For instance, in the areas of intellectual property, digital trade, financial services, and indeed for agriculture, we think things are going pretty well. In agriculture, we're pleased at the initial reports that we will continue to have duty-free access, tariff-free access to the Mexican market, and we hope that a similar outcome with Canada as well. One of the areas we understand is under negotiation with the Canadians is access to the Canadian market for U.S. dairy products, which is subject to some limitations under the original NAFTA. Other question marks we have, as some of you may know, the United States imposed tariffs on steel and aluminum from Canada and Mexico. I believe it was on June 1st. And Canada and Mexico have retaliated with tariffs against certain U.S. exports. We in the U.S. business community would very much like for those tariffs and the retaliation to go away, but it's unclear what the plan is here. We feel we've been led to believe that upon reaching a NAFTA agreement, those tariffs would end. We are certainly advocating for that to be the case. So why don't I stop there and turn it back over to Mark for a Canadian perspective on the negotiations.
Thanks, John. So in terms of the discussions that are happening right now, as some of you may have seen in the news, the Canadian Foreign Minister, which is the senior cabinet secretary responsible for the NAFTA negotiations, Chrystia Freeland, she's gone back down to Washington this morning to resume talks with the U.S. Trade Representative, Ambassador Lighthizer. Now, in terms of the state of play between the U.S. and Canada, there's a number of issues that I would classify as being the kind of big, high-profile ones, and I'll focus on those in a second. And then there are the less high-profile but technical but equally important issues that bureaucrats will be able to solve most likely together at their level without having to escalate them to cabinet secretaries for a decision. Now, the two sets of issues eventually do have to kind of be wed together and then Mexico brought back into the process. And as John alluded to earlier, there will have to be a trilateral discussion at the end of the day to kind of stitch the whole agreement back together so that it's all done by the end of September. And we can maybe speculate a bit more about that in the Q&A session. So what I'm going to do is focus on those high-profile political ones. I think there's about 6 right now between the U.S. and Canada that need to be resolved, I think, before we're going to be able to bring this to a conclusion and as I said, go back to those trilateral discussions to wrap it all up. So the first one is to do with government procurement. In this sector, as I said earlier in the presentation, Canada had come into the negotiations hoping to see a further opening up of the U.S. procurement market. And unfortunately, that has not been the position of the United States to date. What Ambassador Lighthizer has instead tried to do is put something on the table called a dollar-for-dollar proposal, which, given the disproportional nature of the economies, would effectively mean that Canadian companies would have a very hard time accessing U.S. procurement contracts. And certainly for Canadian companies, there's a lot of opportunities in the U.S. procurement market, and this would be a big hit to Canadian engineering services firms particularly. The Canadian chief negotiator, just for reference, actually described the U.S. procurement offer as being one of the worst possible that could be made, and that would mean Bahrain would actually have greater access to U.S. Government procurement contracts than Canadian companies would. The second issue that is sort of escalating at the cabinet secretary level perhaps might sound a little technical at first glance, but that's to do with the financial services provisions in the agreement, and there the Canadian financial sector has a fairly conservative approach to how it goes about regulating itself, and so a lot of how the Canadian government views the role of regulations in the banking and insurance sector has been informed by the 2008 financial crisis, and some of the U.S. proposals around so-called data localization could be potentially problematic for Canada in that Canadian regulators want to make sure that they have unfettered access to data that banks hold on demand, and so it remains to be seen how that issue will be resolved, given that it appears the U.S. and Mexico have reached some sort of agreement between themselves on that matter. The third one is the cultural provisions, and this is something that you see in the Canadian media talked about quite a lot. But essentially, what these provisions are in the trade agreement are exceptions that Canada seeks to its trade commitments, which would allow it to undertake either perhaps subsidies or Canadian content requirements for Canadian media outlets that otherwise would violate their commitments under the Nafta. And this has long been a concern of the United States, and Ambassador Lighthizer, we understand, is pushing this issue quite significantly at the table. The last three of these kind of political level issues, I would say, are the ones that are perhaps the most difficult of the most difficult, and those are agriculture, intellectual property, and dispute settlement. So maybe just to take each of those in turn, within the agriculture sector, the way that Canada structures its dairy market is it's different than the United States. So rather than dairy farmers receiving direct subsidies from the government, there is something called the supply managed system, where the government regulates essentially the domestic production of dairy and cheese and yogurt and all the sort of processed products that come from cow's milk, and to make sure that the market is then sheltered from external competition, they have a fairly high set of tariffs that apply through something called tariff rate quotas, which, for those of you who aren't familiar, means there's a lower tariff rate within the quota, and then any product above the quota level has a much higher tariff. And so in the case of Canada, when you hear Donald Trump refer to these 300% tariffs, what he's talking about is that out of quota amount, which includes products like cheese and butter that will be subject to those. So and what this in effect means is that by guaranteeing Canadian dairy farmers a return on their product, they don't receive direct subsidies from the government, but instead, I guess you could argue, they receive sort of government-sanctioned subsidies from consumers. So the United States has long been concerned about this system, particularly dairy farmers, as I'm sure some of you may be aware, in states like Wisconsin and New York, where there's overproduction in milk. And so as we understand it, there's been some fairly ambitious proposals from the United States to ask Canada to dismantle the whole supply management system and liberalize the entire market. We at the Chamber don't see that as being a likely outcome. What we expect, rather, is that the Canadian government will probably seek to make some concessions along the lines of what's been done in other trade agreements, but of course that remains to be seen. The sort of fifth issue on the political list is the dispute settlement provisions. Now, the view from Ambassador Lighthizer is such that these trade agreements wrongly step on the power of U.S. domestic courts, particularly when it comes to trade remedies cases, so anti-dumping and countervailing duties, which for those of you who aren't familiar with the jargon, an anti-dumping case refers to an allegation that a country is selling a product at below market prices, and that countervailing duty is when a product is being illegally subsidized by the home government. And so what the Nafta has set up in something called Chapter 19 is a special dispute process where if one of the Nafta parties imposes a anti-dumping or countervailing duty, then a complainant Nafta country can go and take those to a special Nafta tribunal to have them overturned. This is something that the the U.S. and Canada fought significantly over in the 1980s, when it was still the U.S.-Canada Free Trade Agreement, and in the negotiation for that deal. And so the Canadian government is very keen to ensure that these provisions stay in the agreement, whereas Ambassador Lighthizer and some people in U.S. Congress that you'll see want to remove these provisions because they argue that they sort of cede on what should be the domestic prerogative of U.S. courts. I think it'll be interesting to see how this one plays out. We've heard some discussion that perhaps there could be a way to combine dispute settlement mechanisms in there, but we've yet to see anything concrete as to what the direction is going to be for this one and how they're going to solve it. And I suspect that this will probably be one of the last issues to be negotiated. The last thing is intellectual property, and there's several issues within the intellectual property basket that the U.S. and Mexico advanced in the agreement that was reached between themselves at the beginning of last week. And they touch on areas like pharmaceutical patent length, copyright terms, the provisions for border guards and the seizure of suspected counterfeit goods, and even provisions to do with geographic indications, which refer to sort of protected names that you associate with associate a food with a particular geographic region of the world. So if you think about Champagne and France as a for example, and that might pose some problems given Canada has agreed to protect these so-called geographic indications for Europe on a number of cheeses and meats. So across the IP chapter, and again in the Q&A we can get into this a little bit more, but across the IP chapter there are a number of things which would represent a fairly substantial tightening of Canada's intellectual property laws, and these have again long been complaints of the United States about how Canada protects, or I guess more correctly, lack of protection for IP. And so given the sensitivities here for a number of sectors, it'll be interesting to see how they work this out. But I think in terms of all the issues I've just listed, there's nothing there that can't be negotiated upon if there's a degree of flexibility on all sides. Certainly when we talk to the Canadian negotiators, I mean, they'll speak a little bit about how they're trying to find creative ways for a lot of these issues to be resolved. And it really does come down to what is the political will of the politicians to be able to make this all work and come together. The Canadian government has been using a mantra all along that no deal is better than a bad deal. Now, I don't think there's any one definition of what a quote-unquote bad deal could look like, but I think depending on who you ask, everyone has different opinions. So one of the issues I didn't list here in the top six more for brevity, but for example, if there's a issue that the United States is pursuing called the de minimis threshold, which has to do with anyone who orders a good online, what is the cutoff point at which the package is deemed to be valuable enough for customs authorities to assess sales taxes and tariffs on it. And so, there's a lot of Canadian e-commerce companies and SMEs that would want to see that threshold raised, whereas more traditional bricks and mortar stores in Canada would like to see it kept at the current level of $20. And again, that's just an example of the sort of constituencies you're having to manage here in Canada. Maybe I'll just sort of end off then by saying, in terms of sort of what we're looking for in next steps, the timeline that John articulated for the end of September to produce a final agreement is our understanding here as well. I think there are an increasing number of people in the Canadian media that talk about perhaps there being some flexibility in there, and that Congress can choose to interpret its own rules flexibly in a manner that would allow a bit of push beyond the end of September. I mean, I don't think anyone here would want to take chances on that. So that very much is the timeline that we're all working towards. And I would say maybe just more on a sort of ending off on a bit of a personal note, having been through these trade negotiations in other contexts, I mean, we fully expect there to be drama as the days drag on. I mean, there's been relatively little so far, but I think it's definitely going to get more difficult as we go ahead in the coming days, as opposed to easier, given that we're touching on increasingly difficult issues for Canada in these negotiations.
Well, great. Thank you guys for the update, and just want to let everyone know that go ahead and enter your questions or raise your hand if you have any, and we can start to transition there. And I do have a question here that I'll kick off with. We have a participant who is asking whether or not you think, and this is related to the automobile area. Do you think there's an opportunity to utilize blockchain technology to identify and prove sourcing of car components to meet the requirements?
Well, it's an interesting question, but you know, it's the sheer expense of creating these systems is likely to run into the tens of millions of dollars. You know, I suppose I don't know a lot about blockchain, but it might be a good system, but that doesn't mean that the system isn't really expensive to establish. And beyond that, the requirements that might require companies to stop sourcing certain components, say from the European Union, that's something that would introduce even larger expenses for OEMs and others in the auto sector that have set up a global supply chain in a certain way, and now they're being told to do it differently. And this is all something that I think we can look upon as something that doesn't add to the competitiveness of U.S. manufacturing. So that's I think the real challenge that we face here.
All right, I have another question. What can we do as chambers to pressure our elected officials to get a deal done ASAP?
Well, by all means, you should be reaching out to your members of Congress and directly to the administration. Now, Congress has a very important role here. The Constitution gives the exclusive authority to regulate foreign trade to the Congress, not to the executive branch. But Congress has delegated some authority here to the executive branch in the sense that the executive branch negotiates, but is under an obligation to consult with and heed the input that they get from Congress. Also, under the 1974 Trade Act, it is the law that the administration is supposed to listen to the private sector. And that makes sense because at the end of the day, it's not governments that trade, it's private businesses that do so. So there's a perspective that comes from industry and agriculture that is real, that's informed by the real world. And so whether it's administration officials or Congress, I encourage everybody to reach out and make your views known about the content of the agreement, about some of these pending issues. And at the end of the day, an organization like ours, the U.S. Chamber, we're going to have to wait and see the details before we assess with our members whether or not we can support it.
Okay, any other questions, folks? I don't see any hands raised. If you have any questions for our two speakers, please let us know.
So, Will, maybe just while folks are thinking about questions they want to ask, if I can maybe just build on that second question and make a shameless plug for a group that the Canadian Chamber has started called the Coalition to Keep Trade Free. what we've started in this coalition is a group of businesses that want to, as the name says on the can, keep trade free within North America, and we've put together a toolkit there on the importance of the U.S.-Canada trade relationship that companies can freely access and certainly draw upon in their engagement, either with government officials or their association members. And you can go online to www.keeptradefree.com, relatively simple. And certainly if people are interested in joining, we'd be happy to have associations from both the U.S. and Canada participate in this.
Great, thank you. And then I had another question about a sample letter as well. And I know, John, I believe there's a tool on the U.S. Chamber's site. I think if you just go to uschamber.com/NAFTA, you can get to it. But I know that there were a few hundred chambers of commerce who came together through you guys, the Chamber Federation, to send a joint sign-on letter, and there's still some online tools that folks can use if they want information.
That's right, and there's also a website called the North American Economic Alliance, which the U.S. Chamber, the Canadian Chamber, and our counterpart in Mexico put together. There's good information there. You can access tools like look for help on drafting an op-ed or a letter to the editor or sending a letter to Congress. That's the North America Economic Alliance. The URL is naeconomicalliance.com. But you can get to similar tools through the U.S. Chamber website as well, which is www.uschamber.com. So plenty of resources available.
And then speaking of our partners in Mexico, we had a question that said, could you provide an update on what the agreement with Mexico states? So are there anything in particular related to the news last week that you could fill the group in on?
Sure. Well, when I made my comments about the auto provisions and the investment protections and so on, I was largely referring to what we know about the agreement in principle reached by the U.S. and Mexico. You can find more information from the U.S. government on the USTR website. That's ustr.gov, and they have, I think, 3 fact sheets available on that the agreement in principle with Mexico. One focuses on manufacturing. One focuses on agriculture. One focuses on, so-called 21st century issues like digital trade and intellectual property. And for those who are really interested, you could reach out to me, and we're preparing a memo that we'll be making available to Chamber members as well.
Great, thank you for that. And then a timeline question here from a chamber whose member companies are getting restless. I know we had a quote-unquote deadline last week. Is there a definitive or somewhat semi-definitive timeline for this process, or is everything still up in the air?
So, we do have a bit of a deadline here, which we could miss, and negotiations would go on. And that's the one that is based on the Mexican government leaving office on December 1st. And working back from that under the U.S. Trade Promotion Authority law, that's the legal deadline, which says that the U.S., Canada, and Mexico must conclude an agreement this month, like a really completed agreement with a scrubbed legal text that they can publish online, and do so by the end of September. That has to be available online for 60 days before it can be signed. So that's the end of September deadline. Then there's 60 days of waiting, and then it can be signed. Now, if we blow past that, our understanding is that negotiations will continue, but it'll be a little more complicated because on December 1st, that new government will be coming in Mexico, and they have somewhat different priorities. The president-elect, President Lopez Obrador, President-elect Lopez Obrador, is Mexico's first left-wing president in many decades, and he has his government is expected to have a different perspective. So that could introduce a considerable delay as he gets his team in place. As president-elect, some of his aides have been participating in the negotiations. He's prepared to support the agreement if it's concluded here in the next couple of weeks. But waiting beyond December 1st for would probably introduce new demands from the Mexican perspective. So it's likely to complicate things, and negotiations could really drag on.
All right. Have a hand raised now. Joshua Mong, are you on the line? If you're on the line, we've unmuted you so you can ask your question.
Yes, I was wondering if we could get a one sheet of some of the data sources that you guys mentioned and some of the highlights of this presentation, just for when we go out to our members and we talk to them, we can kind of use the same talking points that you guys have already outlined.
I'll be happy to provide something to the organizers of the call who can make it available.
Yeah, thank you.
Sure, I will send.
Likewise, happy to do that. Mm-hmm.
Yeah, and on some of the resources that have been mentioned before, I know there are some good there's some good state-specific data available as well for as you're talking to your members of Congress as far as economic impact information and things along those lines available on both chamber websites as well. All right. Well, I am not seeing any other questions or hand raised. Any other questions before we wrap this afternoon? And again, if you're on this webinar, I'll send a follow-up email that gives you the links and some of the additional information that we've discussed here today. One last chance for questions. All right. Well, John, Mark, really appreciate you taking the time to give our members an update, and we'll stay tuned to all of the great information your chambers are putting out to keep getting the word out as best we can. So appreciate your time today. Thanks everyone for joining the webinar, and we'll go ahead and end it. So thanks everyone.
Thank you all.
Thank you.